Chapter 10 is something a little more relatable to you when it talks a lot about getting a job and maintaining a job, getting your contract, teaching certificate, your rights, student rights, discrimination. It's just more practical stuff, and I think you'll enjoy it. It was a lot more fun to do this lecture than some of the others. It also is a little shorter, and you're going to help me carry some of it this time, but I think you'll enjoy it. Chapter 10. Well, this chapter 10 on the legal perspective starts out with the image like the others, and they try and give away a little of the information this way. As you look at this, it's a court proceeding with a stenographer taking notes there and somebody deposing a witness. And unfortunately, maybe fortunately, but this is what our schools have come to be. In fact, I believe we are paralyzed in school from doing the right thing because of fear of litigation and what it costs and all the ramifications of it. So throughout this, as they try, as this chapter, these authors and myself try to prepare you for this, just know we will run from anything that looks like it could get a little sticky. And I think it, like I said, it absolutely paralyzes us as teachers, as administrators, as school, because of that fear of being litigated against. So let's take off on it here. Let me beef this up a little so you can see it. Not quite that much. So what are the legal aspects of this? The newest thing here in the highlight is social media, and they do a nice job of talking about this, not only for you as teachers, but as students, including people losing their jobs, being sued. And the most horrifying thing, of course, is people losing their lives over things through social media. So where does this come from? Well, it starts here in the highlight that the U.S. Constitution, the Bill of Rights, it evolves from interpretation of the Constitution, because there's no mention of it in the Constitution whatsoever. It was really taken upon themselves, and there's a number of things. And if you're a statist, if you're into federalism, you love what's happening to education in the preceding years. But for the most part, it's not mentioned at all in that. So several additional sources of laws exist at federal, state, and local levels that come into here, that mostly addressing disputes. And this is what I say, we don't want to dispute, we will just give up. If there's a dispute, give up. That's what we do as teachers. We just disallow, paralyze kids, freeze things. So some laws are developed out of the legislative process. Okay, and these are called enabling laws. And let me take you back here as we look at these. Here are the different ones. Like here is enabling laws, and laws that make it possible for educators to do certain things. Okay, so and that also laws that impose restrictions or prohibitions. Another form is administrative law, and that's rules and regulations the executive branches of government create, and schools must follow them. And then case law is what comes from the court, federal and state courts and lower courts, but case law, and I maintain that this case law has had more effect on schools and what we do than administrative law or enabling laws for the most part. It's case law that paralyzes us. I don't want to be sued. I don't want any trouble. I don't want any trouble. I don't want any trouble. Okay, and the last, this judicial interpretive process, and that's drawing conclusions about the intent and the wording of the Constitution. And boy, you talk about something that's loose and mushy, because this is a one that changes over time, that interpretation, because it can be interpreted one way now, and another judge comes along, has a different interpretation of it. Appears that has been violated. Okay, so let's talk about this legal provisions of this. So how does federalists get involved? Federalism. So the Constitution, I'm going to add this caveat, supposedly is the law of the nation, where we've trampled all over it in recent years, but let's go with that for today. When Congress develops a new statute, it must be in accordance with the Constitution. except for like health care, No Child Left Behind, those things, that there's absolutely no provisions at all. They still impose those things. The last administration imposed No Child Left Behind on us. They have no authority to do that, but they did. I'm not arguing whether it's good or bad. I'm just saying the Constitution really doesn't provide for it. But if you stretch and mold and pick at the Constitution, you can find some grounds for it, as they have done. Okay. When a state legislature develops a new law, it must be in accordance with the Constitution, United States Constitution, and the state's constitutions. So 3 of the amendments, and again, I'm going to say to you, this is a stretch. 3 of the amendments to the U.S. Constitution are particularly significant to governance of the education, both public and private. Interpretations by the courts of each of these amendments, 10th, 1st, and 14th, have had profound impacts on the role and purpose of schools, the opportunities of all students to have access to it, and the responsibility and the rights of teachers, students, and school administrators. So their point is this, that because of these amendments, this gives authority to the federal government to be involved in your classroom. So here I'm going to, it's the 10th and the 1st and the 14th here, and I am going to ask you to bring those in here. Does not mention education, like I said. So you bring a note about this, and this will be our number 1. Right here, those 3 things right there. And the first is, Congress shall make no law representing an establishment of religion or prohibiting. And that one often is overlooked, not spoken, left out. Make no law respecting an establishment of religion or prohibiting that. And where that comes from, we don't really tell you about this in history, but where that comes from is many people fled to this country for freedom of religion. And what were they escaping? What religion? Well, it was Christianity, but it was state religion. In England, as it is today, the government and the Christian church are interwound, and that's why so many of the first settlers here were Europeans. And now I know the history books that you studied, it was about freedom of economics, that people came here to, steal and pillage and run crazy. But their history books, for the most part, always stated freedom of religion, even though we've scrubbed that out of a lot of the history books today. So this is why in the Constitution they felt so strongly about the state not establishing a state religion because of the bad experience they had in England. But they also knew how important religious faith was, so they added this, or prohibiting the free exercise of religion. And that's the one I think we've certainly, in schools, done all we can possibly do to keep from establishing, but we've trampled all over this one, prohibiting it. Or abridging of freedom of speech, or the press, or the right of people peacefully to assemble, and to petition the government for redress of grievances. And again, for the most part, the government does not like that if you want to petition the government. That's not looked at peacefully very well. So that's the first, and you'll bring that in. The 14th is, no state shall make and enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, and property without due process law. Well, that's not entirely true, because the unborn are deprived of life. Nobody speaks for them, and no matter how you feel about that law or that statute, if you're unborn, you have none of these. And why that's curious to me is because we have people in prison that gave birth and then immediately killed the child. They're sitting in prison. But had they impugned that child an hour earlier before birth, we would say it's your choice and go ahead and do that. So that's really confusing to me, especially in light of the 14th Amendment. And you can go wherever you want with that statement, but it's very peculiar to me. And this I clipped for you on the clip page for you to bring in. So let's do that right about here. And we're going to call this number 2. And it's 10.2 clip. Goes right there. Okay, and we got one more to look at here. Where did that one go? 10th, first, oh, and the 14th. I'll make no or enforce any law which abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty. Oh, that's the one I was ranting about, yes. Nor deny any person with its jurisdiction equal protection of the laws. And they're saying that's you and students have equal protection. You have the right to protect yourself. You have a right to hearing. You have a right to be heard and defend yourself in court legislatively. And why that's important is because there was a time that wasn't thought to be. So the application of that 14th to public education is considered in this chapter deals primarily with the Equal Protection Clause. Let me highlight that. Equal protection, that you and the students have equal protection. Just because you're in school doesn't mean you check that at the door. It goes on, nor shall any state deny or any person with its jurisdiction the equal protection of the laws. So I say if you're charged with something or being discharged, you have the right to a hearing in the court process. That's due process. Okay. So let's get into this bigger one that we got here. Their constitution settles disputes over constitution. So what about church and state? Yeah, this is the sticky one, and probably the one, I shouldn't say, it's one of the ones that schools run from any semblance of this. And that evidence of that, of course, is how we have now scrubbed so many Christian things out of schools from the time when there was Bibles and Ten Commandments and even crosses and prayer in school are all gone, and it's hiding from the courts. So it acknowledges, these authors interestingly acknowledge this strong religious heritage. And it's so interesting that we're so into encouraging folks to hang on to their heritage, except this part is discouraged. But people coming new Americans to this country, even those that have been here, are encouraged to hang on to that heritage, but not this. For example, colonial times education was primarily a religious matter, and many of those who attended were destined for ministry. Okay, so it goes on that court cases concerned with separation of church most frequently involve both First and 14th, meaning due process and freedom of speech and religion. The First Amendment is interpreted as being applicable to the state's 14th. State that requires a daily prayer to be read in classrooms throughout the state could be interpreted as depriving persons of liberty. So that's the approach. If you're forced to pray, we've deprived you of your liberty. Okay, and as the states establish a religion, or at least prohibiting the free exercise of, states are not permitted to make laws that abridge the privileges of citizens, and the right of the free practice of religion must be ensured. But for the most part, it's not. Lots of court cases now about the kids that can't wear religious symbols, can't wear religious things on their shirts, on their clothing, stuff like that. I shouldn't say religious, mostly Christian things, because that's who bring them. Court cases related to the separation of church and state can be classified in three categories. Those dealing with the use of public funds, that's a big one. What about the funds? And then those dealing with the practice of religion in public schools, which is more what you think of. And then those dealing with the rights of parents to provide private education of the children. So that encompasses the fights over separation of church and state in school. Who gets the money? Can money go to religious education, to private schools? 2, can we have any religiosity in the public school? And 3, what is your right to provide a private Christian education or private religious education? And then tons and tons of cases about each of those. Okay, private schools today, religious debates over funding, prayer, and curriculum abound. Often first and fourth, use of public funds to support religious education, practice public schools and parents are this. So let's go on here. Public funds, recent year of which statistics have been compiled, the students who attend non-public schools, 39% were enrolled in Catholic. We've talked about this before. from 2009 is this data. Said 39% that are not in public schools are in Catholic schools. In states with relatively large enrollments in parochial schools, ongoing efforts have been made to obtain public financial assistance, one form or another, for non-public schools. Did you know that? Yeah, there is some public money that goes. Now it tries to clarify this. These attempts have often been challenged in the courts. Present a sampling of these cases in the issues here to illustrate this. Well, here's one: the transportation of students, church schools. Case of the comes this in 47. Court held in this in using tax-raised funds to reimburse parents for bus fares expended to transport their children to schools in New Jersey. Let's see where this goes, and I can come back. And it was found that it did not violate the Establishment Clause. The majority of the members of the court viewed the New Jersey statute permitting free bus transportation to parochial school children just as public do. It's like a public welfare they got to help get the children to and from schools. Since the Everson decision, the highest courts in several states, under provisions of their own constitutions, have struck down that authorizing expenditure of public funds children at schools. Others have upheld such enactment. So it's by state. I will say to you, I went to a private school, I went to a Catholic school, and rode the public school bus to school nearly every single day I attended there. So these tables I did not clip for you because they're so massive, but this gives you here about private education, and you can follow this down if you're interested in this about how we got to where we're at. You can see the dates clear back to here. This is the one we just spoke of, Everson case. Can we have tax money to get kids to school? Okay. This one we're going to study, this Lemon versus Kurtzman, provide direct aid to select care service to non-public schools, including teacher salaries in this. And this the court said no, unconstitutional. Okay. This one, Woolman versus Waltner in 77, provision of books, standardized testing, scoring, diagnostic service, therapeutic and remedial services, non-public pupils. Court ruled that providing such materials and services was constitutional, so public education could. And I will say to you, I went to school in the 70s. We had lots of textbooks. Almost all of our secular textbooks were from and were stamped with the public school stamp. And then this one, in that same court case, provision of instructional materials and field trips to non-public schools, they ruled this was unconstitutional, that part of the law. And here's one, Grand Rapids in 85, and here's another two of them the same. Instructional of non-public school students in supplementary education by the public school teachers, and they found that this did violate the Establishment Clause. So that was a change. This one here, Zobrist versus Catalina Foothill Schools, provision of a school district's interpreter for a deaf student attending a Catholic school. And of course, that was found that was permissible, that they could provide that. And then, how about this one? Is where it got sticky. 94, creationism. Creation in support of public school districts for Hadistic Jews of New York State, and violated the Establishment Clause there. And then in 97, school district's provision of Title I teachers to serve disadvantaged students in religious schools. Court overturned a ban provided the districts assigned teachers without regard to religious affiliation. In other words, you couldn't make them have to have your beliefs. You couldn't have that. You can do that. It doesn't talk about this in the text very well, but for example, where my kids went to school, they had to sign a proclamation that they were a born-again Christian. If you're not familiar with that term, it doesn't matter because it won't apply to you then. But the people that involved in that school, every one of them without exception, knew what that term meant, and so they had to sign that. But they're saying here you could provide a Title I teacher to that school for the poor kids, but you could not apply that same thing from that. And then it's some other things about removing religious symbols from the classroom and stuff like that. And so that was that. And then this came, the Lemon test, and I believe this one is the one that's on the test. And on the test it asks, what are the questions that you ask from the Lemon test? And this was found in a case in 71 about the entanglement of this. And let me just read this to you. The case was dealt with an attempt by the Rhode Island legislature to provide 15% salary supplement to teachers who taught secular subjects in non-public schools. And the statute of Pennsylvania provided reimbursement for the cost of teachers. And of course, the folks were thinking they were doing a nice thing here by simply just paying 15% of the salary if they were in that private school teaching secular subjects, and they thought they were fine on this. And of course, it made itself all the way to the highest court, and it concluded this cumulative impact of the entire relationship arising under the statute. Let me slide over here. And here is the 3 questions that come with that. And this is what you'd have to know in the test list. Does the act have a secular purpose? It better be yes. And 2, does the primary effect of the act either advance or inhibit religion? And 3, does the act excessively entangle? And of course, that is what we can argue about the rest of the day, is what does entangle say? But does it entangle government religion? Most subsequent cases dealing with these funds in non-public settings have referred to this test, that you would ask those 3 questions before you would entangle the 2. And then this is interesting. Let me bring you back here. Here's the Lemon test. Separational clause that you could do this, but infamous 3-fold Lemon test. Have a secular purpose, either advance or inhibit religion, or does it act excessively entangle government religion? Most case addresses have criteria. Now here, I want you to make a note, and this will be number 3. What about special situations here? And so I'll let you look at this, and this is what always complicates it, is special cases or special situations. So the U.S. Supreme Court seems to have wavered from a strict application of the Lemon test in 2 more cases. So here's the law of the land, the Lemon test, and then we waver from that a little bit on these cases. Okay. Severe children with disabilities in this village of Hasidic Jews in the form of religious favoritism violated the First Amendment. So there's a special school for kids with disabilities that were Jewish, and they wavered there whether a public school district could provide the interpreter for a student who was deaf, and so we have that one. So those 2, you mentioned those 2 things for special situations. Okay. So what is this child benefit theory? The use of public funds to provide secular services has led to a concept referred to as the child benefit theory. And they do pretty good here. Public funds for secular services. So the courts found, yes, you could use public funds because it would be a benefit to the child. And here's the things they could do is transportation. As I said, I rode the bus. Textbooks, the secular textbooks. No, we don't buy you Bibles. We don't buy, religious textbooks, but secular textbooks. Reading and writing and arithmetic and writing, and science, we'll buy you textbooks for that. And this was a newest one that we will buy with public funds because it's best for children. Testing, diagnostic, therapeutic, and remedial things. So that's all. That's the child benefit test we give it. And the services must benefit student, not school or religion. And that you would know. And this, a lot of this, I was outright of this. No Child Left Behind allows for funding for private school students. Any money that would come down. That also upheld limited use of Title I funds at private schools. Remember what it said? That it could be, but all the things came into play in the textbook where the couldn't apply the same litmus test to hiring them, couldn't have religious symbols in the room where the services were going to be provided. So that's what that theory is. And it's 2 I clipped, and so we're going to move this. This is 10.3, and I'm going to put that at the bottom here. And this is number 4 and 10.4 clip I want you to put here. And the reason I have you do these clips is I want you to have that in your notes, not only today, but going forward. The textbook's going to go away, but hopefully with these digital notes, you'll be able to access them someday. Or if nothing else, you'll have them to study for the assessment, the quiz on this, but I have you keep inserting these things into your notes so you have them and have them for the study. All right. Then here's the thing about Title I teachers in schools seem to be providing increased flexibility and easing the tension created from this law. In 85, court struck down the use of Title I's funds to pay public school teachers taught in the programs, but this ruling, the court decided that under specific safeguards, Title I teachers can be sent to serve disadvantaged and religious schools. Okay. And it's just based on that religious school could have a population that meets those. And I said I was a free or reduced lunch kid 40 years ago, 35 years ago, and so that's the way that plays out. All right, 10.3 we did. Okay, and then how about religious activities? And this is so interesting, this image here, because for the most part of us here in the plains, we're very used to this. It was almost automatic that there was be some kind of a blessing that you would ask for. And now, of course, for the most part, it's completely prohibited. And this is the thing that schools, rather than stand and fight, ran like little girls, rather than try and defend this right of students and coaches to pray. And I'm just going to say how we do it. We still pray over our kids every time they compete. But what we pray, number one, is they're safe, and we see the injuries, and our kids have been hurt, and you could tell as many stories I could about severe injuries in these sports today. But the other thing that we pray is that they're godly in their interactions and the way they conduct themselves, and of course that we as parents can be godly too, because we can get a little out of hand too. So how about the religious activities in the public school? Talked about that. Religious activities. How about prayer in school? Well, boundaries of First Amendment in school. Many cases have dealt with a prayer in school, teaching of creationism and evolution, the rights of the public facilities. Each case contributed to a gradual process of clarification of what can be done and what should be done to ensure the separation of church and state. All right, prayer in school. A number of attempts have been and continue to be initiated by school districts to incorporate some form prayer into public school classroom activities. One such case began in Santa Fe, New Mexico, and Santa Fe High School in Texas. Adopted a series of policies that permitted prayer, initiated and led by students at all home athletic events. That's all they're saying. No adults, initiated and led by students. And everybody thought that was fine. That went on a while. But in 2000, Supreme Court ruled in the Santa Fe Independent School District versus Jane Doe that the clear intent of the district policy was in violation of the Establishment Clause. Okay? Clear intent, and I'm not sure how they know that. 6-3 majority. So let me ask you this. If the clear intent was this, then why is it a 6-3 vote? Why wasn't it 9-0? I don't get how they knew that if not everybody agreed that. But anyway, they said that can't happen. Nevertheless, ask us to pretend that we do not recognize what every Santa Fe student understands clearly, and that is the policy about prayer. There in the decision, the court noted the policy likewise does not survive a facial challenge because it impermissibly imposes upon the student body a majority in the election of the issue of prayer. In other words, the district would be imposing a particular religious activity on the majority of all. Clear violation of the Establishment Clause. And that's what the basis was. And that was the end of student-led prayer and activities in 2000. Because prior to that, we ended school prayer in the 60s, and up to 2000, the students could lead prayer. But that was the end of it after that case in Texas. Further empowers the student body majority with the authority to subject students to a minority views of constitutionally improper messages. Okay, so that's what happened to that. Okay. And that's what majority religious was. If you allowed that, they said that was like saying this is the majority of this. And often who objects to this is not people from other religions. Rarely these cases, and this is why it is Jane Doe bringing this, because it's people of no faith who challenge this. And they have the right to do that. But that's what happened to prayer in school, and student-led prayer was not other religions, the absence of religion. And then they got into, this is the latest one, evolution versus intelligent design, which I still think is nobody's business but the schools, but the courts got involved, and the curriculum people got involved, and Common Core will be involved in this. They'll soon dictate this. But this debate is traced to the publication of Origin of Species by Charles Darwin in 1859. So that's what I want you to put here. This is number 5. And I'm going to put it right here. Number 5, Darwin. You put that whole thing here, this whole sentence here. The debate is traced to the publication of Origin of Species by Charles Darwin in 1859. That was the first anybody cared about this, or where it was hatched. Okay. And following years of careful observation and documentation of the characteristics of plants and animals, Darwin theorized, remember this is 1859, he's come up with this, theorized that today's animals and plants were a result of natural selection over thousands of years. In other words, evolution. In approximately 150 years since that publication, the scientific base for evolution has become well established. And I wholeheartedly disagree that, like most science, when they couldn't find their way, they created stuff. There is no solid evidence for this, but let's give old Darwin the benefit here. A record more recently analysis of the genetic history of plants and animals. Some religious perspectives and a large proportion of the population view evolution as a unproven theory. Doesn't matter. It's now law of the land in a lot of schools. A lot of states have adopted that's the law of the land, even though it's unproven. The critics have used various strategies to challenge its teaching or to require an alternative view based on religion be taught as well. And you see some hiding behind that, okay, we'll teach both. But many states are saying we're not going to teach both. We're only going to teach evolution. One of the most famous trials involved religion teacher occurred in Tennessee in 25, and it had to do with Scopes, and they called it the Scopes monkey trial. And I'll let you read that part of it there. I clipped this one also in the cases that led to this, 10.3, and so we're going to put that right here. And number 6 is clip 10.3, or table 10.3. Should say table because there's 2 of them there, and you bring that in there, and I clip 10.4 also, so let's put them both here. This is 10.4 also, and this is just a figure. No, I checked on this. Don't worry about table 10.3. Just do 10.4 here. Number 6 will be 10.4, figure 10.4. Okay. Talk about prayer, cases, where that came from. Okay. So the establishment clause is, are you establishing religion? And that's what here is like a separation clause. Is it, are you establishing this? And then evolution, Scopes trial, and then 10.4 you're bringing in figure, and here's the cases for separation of church and state. Oh no, this is the one for desegregation. Let me see where we're at here. All right. I think 10.3, I think I'm going to clip 10.3 for you also, and ask you to bring that in there, table 10.3. Let me do that quick here. Hang on. There. Now you have that too in your notes, and let's put that here. Put that back in there, table 10.3. So table 10.3 and figure 10.4 right there. Okay. And here's one final statement that's very interesting, and I just highlighted the whole thing if you'll allow me. Regardless of the past Supreme Court decisions, some topics, such as posting of the Ten Commandments in classrooms and Bible reading in public schools, continue to be challenged by legislatures, individuals, and various groups. One of the outcomes of these ongoing challenges is an accumulating series of judicial interpretations that can serve as guidelines about what can and cannot be done. The summary statements presented in Figure 10.4 outline the overall pattern of many judicial decisions related to religion in public schools. Okay. And this is the part that I'm saying is hard, is why the schools have now ran like little girls, because they don't want to get anywhere near this word here, court. Okay. They don't want anywhere near that. So to avoid that, we just run. So here's the next big bite. Segregation and now desegregation. It wasn't a topic not too long ago. Let me run over here quick and just show you where we're going. This whole thing on the legal aspects of education, and we're clear down to here now on separation or segregation and desegregation. We'll have this big bite on your teachers' rights, and then the social media, and then students' rights. But we're up here working our way through. All right, so what about this? Well, the troublesome problem in the U.S. society has been the history of legal and social separation of people based on their race. In other words, segregation. And we do a terrible job in this country teaching about history, but you knew that. That becomes a big focus in our history today, is the segregation. Up until the middle of the 20th century, the public school system in many states contributed to this problem through the operation of two separate sets of schools, one for Caucasian and one for African Americans. And again, if you paid attention in history, you know about this. Segregated schools were supported by the courts. So as bad and horrible as we think that people were, state laws and official actions made that. State and local government administrations. This kind of segregation based on legal and official actions is called de jure separation, de jure segregation. Will you say that out loud, please? A little bit louder. De jure segregation. Go ahead. There, good. Because I want you to be able to speak correctly and pronounce those correctly. So there, that's maybe a new term to you. But in 1954 is an interesting year. My dad graduated from high school in 1954. The courts and communities made an intensive effort to abolish racial segregation in public schools. The process of this was called desegregation. And I'm going to say to you, they went crazy trying to desegregate schools. A major instrument for the courts have used to accomplish this is called integration. The busing of students achieved a balanced number of students in terms of race in each school within a school district. So the courts, and this wasn't a courts, this was government, this was powers to be, decided we're going to desegregate these schools ourselves. We're not asking anybody, we're going to do this. So what they did, and there's very little written here about busing, but it was a huge deal. We talked about this in another chapter. Made kids that did not choose to get on a bus and ride across town to a school of a different race and go to school there. Okay, and we want a racial balance. So again, it was even different. And one person in the family maybe gets go-ons over there, another one's back. But one of the things that they forgot was that birds of a feather still flock together, that kids choose their own friends and who they want to flock with. So what happened, of course, they spent billions of dollars doing this, only to find that racial tensions weren't eased at all. In fact, the tensions now were with families, and families were fleeing to get away from this because their kids now were they're living right next to the local neighborhood school, but instead they get on a bus and maybe ride as much as an hour or more across town to a school from a different race, both ways. And so it was never professed, but I'm telling you, it doesn't happen anymore, but it was huge failure, and nobody would say that or take responsibility, but it doesn't happen anymore. A second instrument has been a user of a magnet school, which are schools that emphasize particular curriculum areas, disciplines, and themes. The hope has been that these schools will attract a diverse set of students. Okay, the word is attract. And this it's very contradictive here. Hope was this that they would attract. Okay, these efforts to integrate the schools have mixed success, and that is, putting it politely, mixed, because like I said, what they found is the racial tension heightened from doing that and not letting people select, not letting people volunteer, say get on the bus, that's where you're going. Okay, and now there is increasing concern over resegregation because they stopped the busing based on where people live. Segregation or resegregation caused by housing patterns, okay, and other non-legal factors is called de facto segregation. So not legal. Remember, we had de jure, and now we have de facto. And okay, just go with me now. You know where this goes. What about housing patterns? What does that mean? Well, who tends to live in the low-income housing? And where do we come from? I mean, we had many governments built low-income housing. Who settles in those? Of course, the kids for the poor. And they tend to be somewhat disproportionately minority kids. Oh, we can't have them all in one school. We've got to segregate them or prevent resegregation here. And so what was really frustrating, what makes this hard, is you move to a certain neighborhood for the quality of the school and that type of thing, and then government comes along and says, oh, no, get on the bus, go. And so there's some concern. And they kind of leave this alone here now, a resegregation. But if you choose to go a certain place, it may be for the wrong reason, that you're a racist or something like that. If you send your kids to a certain school, what I think this does is continues to fuel the exodus to private schools and to homeschooling, things like that. But we'll come back to that. Separate but equal is no longer equal. Okay, let me just say here, segregation, and then de jure, and then desegregation. Okay, and then integration, and then magnet schools, or to supposedly attract, and then there's increasing over resegregation, people segregating themselves again. And it's just by where you end up living. And I say what I think is interesting is so often the government, the same government that doesn't like this, created low-income housing that attract people from low incomes. Let's spread those out, and let's not create entire communities that way. Anytime the government gets involved, these are unintended consequences. Okay. So what about this separate but equal? And this is what I'm going to ask you here. What are we on about? Number 7 here. You're going to get to put something here for each of those. 1, 2, 3, 4, 5. And I'll give you a little bit. You come back and put a note, put an explanation for each of those 5. And let me just pick a few things for you. 54, many states had laws either requiring or permitting racial segregation. De jure segregation in 54, lower courts upheld the doctrine separate but equal. But as announced, the Supreme Court in Plessy Ferguson in this court upheld Louisiana law that required railway companies to provide separate things. And so that's what that was. The courts said it was okay to provide a train to take poor kids or kids to a segregated school. And then the failure, here's the next one, failure of the separate but equal doctrine. This separate but equal doctrine appeared to be the rule in 54 when the Supreme Court repudiated it in Brown versus Board of Education. And I would want to say to you, this is what you want to put in there, is Brown versus Board of Education of Topeka. Probably the most famous case in school law was Brown versus the Board of Education in 54. And the court said that the separate but equal doctrine has no place in education. So after the de jure segregation, the same courts come along and said, no, you can't do it. So in 55, the court took more steps and stuff, but that you could no longer, and here's what it is. You could separate, even though both schools were wonderful, it wasn't equal if they were separated. And so now the little brown girl could go to the neighborhood school, and that was the essence of it. and I'll give you a chance to look at that later, but the essence of Brown versus Board of Education was the little girl was going by a neighborhood school that was a very good school, really close to her home, because she needed to go down the road a couple miles to the black school. And her parents, and of course, like any court case, by the time it got to Supreme Court and was ruled, she was out of school or near the end of school, so it didn't really help her, but it had these lasting things of it. And this case here is the court case that led to desegregation and integration into schools. Okay. And then release from court orders, we're up to here. And you'll have something about here as years of court decisions and school district efforts related to unfolded. A new question was raised. What conditions must be in place for a school district to be released from federal court supervision? Because you were put on supervision if you weren't, meeting the requirements here. And so there's some cases here, and you will read this here first. There's a first and a second that you'll want to talk about here, and a third. Okay. And then achieving integration in today's diverse society here. Present, more than 500 school districts have experienced some form of federal court oversight to address segregation. So in other words, they didn't feel like you're segregated enough. The court stepped in. And at the same time, instead of schools and communities becoming fully integrated, there is a clear trend towards resegregation. And I disagree that the schools are doing this, especially in urban areas. As well-intentioned as the efforts have been to erase de jure segregation, de facto segregation is increasing. There's also an increasing diversity in the number of other racial and ethnic groups in most communities. Schools continue to be challenged to ensure that all students have equal access to quality education. And I think that's honorable. I mean, that's what it should be. Let's not worry about segregation. Let's worry about access to good quality education. The current strategy for achieving this end is some form of race-conscious assignment of students. Strategies such as magnet schools, including consideration of diversity admissions. So what we do, we create these magnet schools, and then we set provision, or we give extra consideration to minority kids. Giving priority to siblings in school assignments are being tried. As well as intention of the efforts may be, some people perceive inequality such each strategy is being challenged in the courts. Because what we do, like we so many, is we create these and then we say, but by the way, we're going to give preference to minority or poor kids. And hence what we're going here is reverse discrimination on that. And of course, so that's challenged in the court. So you're telling me that my kid doesn't get to go because he's not the right background, he's not the right culture, he's not a minority kid, so therefore he doesn't get consideration on his own merits? That's what we've done. Okay. So there you have that one. So let's go these court cases here. De facto segregation, race-conscious assignment, contemporary strategies. We'll jump over that. So discrimination. Let me come back here. All equal opportunities, and we're coming equal protection here. Okay. Equal protection clause of the 14th Amendment. I gotta make sure whenever I do this, make sure I'm recording. See the little thing that says recording? That's why I do that, so I make sure it's working. Equal Protection Clause of the 14th Amendment has been instrumental in shaping many court cases and federal statutes that are directed towards preventing discrimination in schools. A judgment of discrimination can be defined as determined that an individual or group of individuals, for example, African Americans, women, or people with disabilities, has been denied constitutional rights. That's discrimination. Common use. The term applies to various minorities or to individual members of minority who lack rights, typically according to that majority. Principle that discriminates violates the Equal Protection Clause was these: Title 6 and 7 of the Civil Rights Act of 64, Title 9 of Education of 72, and their civil rights. So they're here, and you get to come here and put in what these are. These three things. And so this is number 8. Number 8, 1, 2, 3. Okay, and then what is affirmative action? Oh, yeah. 64 Civil Rights Acts, numerous statutes, and court cases have encouraged steps designed to ensure that the underrepresented, that's, you familiar with this term, we've talked about that before, the underrepresented populations have the equal opportunity. These affirmative action initiatives have included such actions as formalizing and publicizing non-discriminatory hire processes and setting aside a certain number of slots in hiring of college admission programs. So again, in my thinking, it's reverse discrimination because we're going to give preference to minorities. Okay, and certainly admissions. So again, my kid may be discriminated against, may be not admitted because he's not the right race. Okay, and over time the concern has increased about the possibility of reverse discrimination in that very thing, that you are left out because of you're not the right race. Situation in which a majority or an individual member of a majority is not accorded equal rights because of different or preferential treatment provided to a minority individual group. This concern has resulted in a new set of court cases, thank goodness, each of which attempting to redress what is perceived as a new imbalance. A summary of the events policies are in 10.5. And again, what happened is, not only in admitted college, we're leaving out very highly qualified people because they weren't the right race or background. And what happened, we did the same thing in hiring of people into jobs and management and stuff. So you ended up with people that weren't as qualified and maybe weren't going to do near as good a job, but they fit the right protocol that you're looking for. And hence that was reverse discrimination. And really, from some places, really messed up some programs and things because of that. Goes on here, as mentioned, legal basis for affirmative action found in these titles. However, affirmative action procedures and methods have continued to clarify increasingly questions. Okay, so I think I will give you this one also. So we're going to say this is 10.5 under here. Number 9 is 10.5 figure. Paste that in there from the clip page. All right. Back. So let me give you this last part here. As of 2012, 6 states, won't surprise you, California, Michigan, Arizona, Nebraska, Oklahoma, Washington, has established bans against using racial and gender preference in hiring, contracting, and college admission. So that's very interesting, and that's to fight reverse discrimination. The U.S. Supreme Court has once again been called upon to define the boundaries of affirmative action. And I'm saying to you, states, please stand by for rulings that will affect you. I've said this before. Let me give you a story again. I was discriminated against for gender. I applied twice for positions in schools that their constant goal was gender balance. And so if there's a school that has a principal and 3 assistant principals, at least one has to be a woman. So if the woman resigns and they're looking for a new assistant principal there that where there's already 3 men, I can apply and be interviewed, but I'm not going to be hired. And everybody knew that. They couldn't. You don't say that out loud. That's not allowed to say out loud, but I knew that was going to happen. And sure enough, in both instances, a woman was hired. Now, I'm sure they were highly qualified. I'm sure they were more qualified than I am, but it helped open my eyes that, hey, don't apply for jobs where it has to be a woman in there. So that I thought was reverse discrimination there. Checking this here. Let's go on to what about the students with disabilities? What about students with disabilities here? I'm going to jump back here because we've done quite a bit of this. The legal basis is grounded in the Civil Rights Act, saying that they have a civil right to be involved in school. Let me go on here. Section 504 is a federal statute. Do you know what that is? Encourage the education of individuals with disabilities by making grants to states and local education agencies for children 3 to 5 require the federal government to be responsive to the increasing ethnic. Do you know they've never funded special ed like was promised when it was passed? When 94-142 was passed. fund programs to provide education to all children with disabilities. So what is 504? Civil rights established in 1973 said if you get federal funds at all, if you take federal money for any part of your business or what you do, you're prohibited from discriminating against otherwise qualified individuals. Okay, and this is why we have 504 plans in our schools, because of course all schools take fed money. And so if you have fed money, you've got to accommodate people with disability. Okay, so note that Section 504 is a federal statute and related regulations, not a court decision. The most important themes in this are equal treatment. And this is what we do in schools. Equal treatment, appropriate education for people with disabilities. And of course, that's a little mushy what exactly that means. Equal treatment as a civil rights context must be addressed. However, this does not necessarily mean the same treatment. For example, giving the same assessment procedure to students with disabilities and others may not be equal treatment. Educational judgments in relation to students with disabilities require a heightened standard. The measures must fit the students' circumstances and stuff. So I want you to make something here. What is 504? And this is going to be number 10. 504. And the focus, of course, is equal, not same, but you make a statement in there. And then a couple things here. This is going to be number 11. Number 11 is what does PL stand for, and what does 94 stand for, and what does 142 stand for. So that's number 11. And number 12 is 94, 142, education of all handicapped children. What's the name of this today? Okay, there's 11 and 12. Do that now. All right. And you know this, the IEP, if you've studied this at all, the IEP formulated by general and special education students with the parents' approval. The law provided for substantial increase in funding. Subsequent years, however, the funding or authorizations had been lowered in the original commitment. And as I say, when it was passed, like so many things the federal government did, they promised the states 100% funding. Never happened. And now it's way down to the, I think 15% or something. I don't know if you could find that specifically, but I know it's embarrassment for what was promised and what's delivered. And the two priorities for funding were a child who currently receives no education and a child who is not receiving all the services he needs or succeed. Okay. And then IDEA, what that means, increased quality and rigor was one part of that. And this is what part of that was, is to align IDEA and No Child Left Behind. Definition of what is highly qualified, to come to consensus. What does that mean as far as teachers? In response to intervention, okay, FAPE, I want you to do this too. I'm not going to put a number here, but I want you to put a big bold this next to it, a FAPE, and it's an acronym that we use in the educational world, meaning a free, appropriate public education, a FAPE. It's on increased quality and rigor, okay, and then IDEA, and then response to intervention approach. There is a question on the test about that, so what I'm going to do is ask you to make a statement about this. Read this here, and number 13 is here, a statement about this. What is RTI? Response to intervention. Not what does it mean, but what are they saying there about it? How it affects you? Part 2, teachers' rights and responsibilities. And you have rights, but boy, let me tell you, you have responsibilities too. Not only to the kids, but your community and to me, the parents. Teachers have the same rights as other citizens, so find comfort in that.